Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, Dovetail or Discord, the evolving relationship between antitrust and data privacy law. Antitrust and privacy have long been intertwined, but new issues and complications exist in the age of digital media and big data. In this episode of Our Curious Amalgam, we explore the evolving regulatory landscape and intersection between antitrust and data privacy law. Joining me today is my co-host, Alicia Downey. Hey, Alicia.
Hi, Christina.
So what are we talking about today?
As you mentioned, there's a growing tension between antitrust law and data privacy law in the U.S. and elsewhere in the world, and particularly as regulators look at the conduct of dominant digital firms and consider data privacy issues in the context of analyzing prospective and consummated mergers. Today, we're lucky to have with us as a guest Professor Erika Douglas, who is a leading voice in the vanguard of thinkers considering the ways in which data privacy and antitrust laws interact with each other currently and how they might and should interact in the future. Professor Douglas is an assistant professor at the Temple University Beasley School of Law in Philadelphia. She's frequently writing on antitrust, technology, and data privacy issues. Two of her recent papers include the new Antitrust Data Privacy Law Interface, published in the Yale Law Journal Forum in 2021, and Monopolization, Remedies, and Data Privacy, published in the Virginia Journal of Law and Technology in late 2020. And if you check out our episode webpage, you'll find a copy of the Yale Law Journal Forum paper there. Before going into academia, Professor Douglas practiced antitrust law at Covington & Burling LLP's Silicon Valley office. She's been an active leader in the ABA antitrust law section for almost a decade. So welcome to our guest, Erika Douglas.
Thanks, Alicia, and thank you, Christina.
Can you tell us, Professor, a little bit about what you've been writing about in connection with data privacy and antitrust?
Absolutely. So, as you hinted at, I've been writing about the really dynamic new ways in which antitrust and data privacy are starting to interact. And I want to emphasize how novel this interaction of law is, just to start off our conversation. So, privacy law has been around for quite some time, from Warren and Brandeis's right to be left alone or privacy torts, but data privacy law is quite new. So remember, although we see data privacy law in the news every day, it was only really in the mid-90s that the FTC started to use its Section 5 FTC Act powers to sort of combat unfair and deceptive practices related to privacy. And that was sort of developed alongside the internet, right? Consumers were suddenly putting their data online. And then we saw sectoral privacy laws like HIPAA and COPPA appear in sort of the mid to late 90s. And if you think about that, alongside the history that this audience knows of antitrust enforcement, that was an era of antitrust quiet. So particularly in monopolization, the last time we saw seminal monopolization cases like Microsoft being brought by agencies, there was no real data privacy law to speak of. And today, both are booming. Both are being enforced in a big way. And so a few years ago, the literature hadn't really caught up, sort of saying antitrust and privacy law are separate. And yes, that's true. They have sort of separate doctrinal roots, but they interact quite a lot. And the literature is also saying they're complementary. So the classic example of this is often data portability. So privacy laws around the world are granting consumers the right to port their data from one service provider to another. And that's thought to also promote data-driven competition. So that was my jumping off point for what I'm writing. And the Yale and Virginia papers that you talk about take the position that there's much more to this intersection. We can't simply say they're separate or they're complementary. That picture was a little bit simplified. Not incorrect, but maybe a bit incomplete. And so my work is really trying to build some depth and breadth around the theories of how we understand these areas of law to interact, And instead of just thinking of them as complementary or assuming they're complementary, to think about the ways where there might be specific tensions, or we might need to think a little bit more about how we achieve complementarity. And so that's what those two papers are largely about.
Hopefully we'll get into the details a little bit more, but I'm curious, what got you interested in these topics?
Yeah, it's a good question, Alicia. I think it was the duality of being in practice and representing a large number of technology platforms and seeing that optimal compliance looked a little bit different for the privacy people than it did for the competition people. So starting to see that the way in which data is treated might be a bit distinct from these two realms. And then coming into academia and seeing there wasn't really much in the way of sort of robust, nuanced theories or full explanations to explain this intersection of law. And it's a pretty stark contrast to another more familiar intersection of law, which is intellectual property and antitrust, where we have a wealth of very well-written cases and texts on it. Whereas for this intersection, which is quite significant to regulation of digital platforms and the digital economy, we don't really have that much. It's sort of a thinly theorized area.
Considering the development of, the related aspects of intellectual property law and antitrust law and how frequently they are paired together, I think there's an entire chapter, in fact, in Antitrust Law Developments, the section's seminal treatise on intellectual property law. What do you think are some similarities and differences, perhaps in the analogy, though, between the relationship between data privacy law and antitrust and intellectual property law and antitrust? Does that analogy hold?
Yeah, I actually teach patent law at Temple too. So I've been contemplating sort of the comparisons between the two intersections. I think particularly for an antitrust audience, the intellectual property antitrust interface is a really useful initial reference point. So we can understand there that antitrust law interacts with intellectual property law, and it also does with privacy law. And that's useful as an analogy for differentiating between two ideas in this space. So sort of idea A is that we might use antitrust to protect privacy. And that was sort of circulating for a while. I would say is largely rejected and certainly not a position that I would take. And by analogy, we wouldn't say antitrust law should be used to protect intellectual property, right? That's just not a proposition that makes sense. And then idea B, which does have more traction and makes more sense, is that the interaction between the areas of law of antitrust and IP is a lot like the interaction between the two separate doctrinal areas of antitrust and privacy. So it's too simple to say sort of that privacy isn't an antitrust problem. That's not an answer. They're different areas of law, but they're going to interact with each other. And so that sort of, I think that's where the analogy is useful. And also in understanding there's going to be evolution in how we theorize this intersection of law. So we sort of thought initially that IP and antitrust were in tension or in conflict. And it became sort of this more subtle theory that they might both promote innovation kind of over the last 15 years or so. I think we're at the outset of understanding how privacy law interacts, and that's going to evolve significantly in the coming years. I think that's where the comparative utility of that analogy kind of ends, because privacy law is quite distinct from IP. And I'll just mention a couple of ways in which it is, which I think is worth noting. We can't take the analogy too far. There's no omnibus federal data privacy right in the US. So that's very different from intellectual property rights. So patent exclusivity is a statutory right. And so that affects the primacy of whether privacy is going to be considered in antitrust analysis, right? The same way that intellectual property is considered. But that may change a little bit if we start to see, so we're seeing at the state level, privacy is becoming a right in the US. And another big difference, which I think is worth thinking about, is that privacy is about the right or expectation of individuals, right? So when a defendant is claiming a justification, for example, if they're accused of anti-competitive conduct, in IP, they're invoking their own right. They are the holder of the patent rights. Whereas when it's privacy, what we're seeing now is platforms invoking the privacy of users as a justification. They're sort of invoking someone else's interest or someone else's, expectation of privacy rather than their own. And I think that leads to some skepticism about whether that's truly what's happening if they're invoking sort of the interest of another party.
So you mentioned at the outset of that answer, the antitrust audience. I know you speak a lot to antitrust attorneys, potentially patent attorneys. What about privacy attorneys, legislators who are thinking about privacy law? What antitrust issues are they thinking about? How does it interrelate to the work that they're doing? And how do you kind of talk to them about antitrust and how it intersects with their sort of practice?
So I think so far it's a bit lopsided. Antitrust is much more interested in privacy than privacy tends to be interested in competition. So typically it's sort of an awareness raising conversation on the privacy and antitrust side. And actually, at the beginning of July, I authored a report for the Global Privacy Assembly, which is 130 jurisdictions, privacy enforcers. And it is about how agencies on both sides think about this. And the main purpose of it is really to raise consideration on both sides of these different issues. So each of the realms, so the antitrust agencies and the privacy agencies have their own specific mandates, but I think it's important they at least can understand how the actions that they take might affect the other side. So if we restrict the flow of data, might that affect competition? If we mandate the flow of data, might that affect privacy? So I think that it's important sort of for both sides to gain a little bit more awareness. I mean, certainly the US has an advantage in that, and that both are housed within the FTC. And so there is a little bit more awareness there. But in most countries, the standard is to have completely separate agencies enforcing the two. So there's a lot of room for additional understanding there.
We're currently in an atmosphere in which there's greater and greater scrutiny being placed on the conduct of large, we'll call them digital firms that both collect and generate masses and masses of data, to which many people say they have a right of privacy. Now, do you think that the data privacy rights are going to become a factor in the consideration of whether that conduct does or does not violate antitrust laws? And if so, in what ways?
Not so much in the US so far, but I think that we are seeing privacy come up in sort of, I would say, three specific ways. If we're talking, it sounds like you're talking a little bit more about unilateral conduct, if that's fair. So privacy, it's not so much privacy rights, but privacy as an element of quality. And what you can see in some markets, particularly digital markets, is that when consumers are making choices between products, now privacy more and more is a parameter of the quality of the products and services that they choose. And so let's be specific here. So the Department of Justice, their complaint against Google, which was filed last October, for example, includes, among many different allegations, the idea that Google is using monopoly power to erode privacy. So to erode the quality of search, including on dimensions like privacy and data protection and the use of consumer data. So that allegation is in that complaint. So that's sort of one of the primary ways, particularly in the US, in which this is coming up. And it also came up in the state's case against Facebook, which was dismissed recently. And so there's not actually that much, I would say, there empirical evidence to show that monopoly power erodes data privacy. I think that we should be a little cautious in assuming that causal relationship, which seems to be getting traction. It reminds me a bit of the Schumpeter and Arrow debate about whether monopoly or competition promotes innovation. And so I think we don't really know yet. That debate rages on, as does this. I think there's an opportunity for sort of economic work on that. But the other way to answer your initial question, that data privacy is kind of coming up in unilateral conduct cases, is something I mentioned already as a justification for allegedly anti-competitive conduct. So once the plaintiff, under rule of reason cases standard, has established with their prima facie case that the restraint on conduct is anti-competitive, then we're seeing digital platforms argue that their conduct was driven by the need to protect user data privacy. That's popping up, for example, in Epic's case against Apple in the Northern District of California. And so we're seeing similar arguments too, for example, in Google's planned termination of third-party cookies on its Chrome internet browser. And so there it goes back to sort of the idea where we started, which it doesn't look particularly complementary when you see an allegation of anti-competitive conduct and a response that this conduct was necessary to protect privacy. So that's really where they're coming up in the US. And then I think it's pretty different internationally in some countries.
Well, you've just anticipated my next question. Can you give us a sense of what's going on outside the U.S. and the different approaches that are being taken there?
A lot. In short, the answer is a lot. Because data privacy law itself is sort of a more compelling power in a lot of other countries. For example, the European GDPR sort of demands attention from competition authorities. And so there are a lot of different, one of the sort of leading examples that's unusual from a US perspective is the German competition authorities case that they've brought against Facebook, which is an exploitative abuse of dominance case that alleges that Facebook is using its monopoly power to sort of obtain excessive data from consumers. So if normally exploitation is excessive price, this is an excessive data sort of argument, it's very unusual because it's fusing together antitrust law and privacy law in a way we haven't seen in the US by saying the abuse of dominance or the monopoly power was used to violate privacy law. So that case began in 2016. It's kind of meandered through the German courts. And as of March, it's been referred to the European Court of Justice. So stay tuned for that. I think it's unlikely to see anything like that in the US, but definitely an interesting example of interaction between these two areas of law. Also, we haven't talked much about mergers, a lot of consideration of whether the reduction in competition from a merger is likely also to reduce the quality of privacy offerings in a market. And the European Commission considered that in the Microsoft LinkedIn merger, the Facebook WhatsApp merger, and most recently in Google Fitbit, where there were actually privacy commitments that were part of the remedy that was imposed as a condition of merger approval. And I think the last sort of headline news on the international front is a lot of agency cooperation. So a good example of that is the UK's Competition Authority and the UK's Data Privacy Authority recently released a joint report on this intersection of law and have reached a memorandum of understanding on cooperation. They're looking closely at matters right now, like Google's end to third-party cookies, where there's really deep collaboration between the two different agencies. And I think that that's sort of the future of what we'll see out there. So sort of developing norms and practices around that agency cooperation.
And from a very practical standpoint, who needs to care about this right now on a day-to-day basis?
Who needs to care about this other than antitrust professors? Absolutely a fair question. And I think it is something that if you care about coherent digital regulation, which a lot of people purport to care about, then it is worth thinking about this space. So data privacy and antitrust law are these major forces that shape the movement of our personal data in the digital economy, and not always in consistent ways. So if you would like to see digital regulation that's effective and coherent, I think that this should be an area of interest. I hope that includes agencies around the world, and as well policymakers, attorneys, and companies who operate in the digital space. I think another entity that's going to end up caring about this is that we're going to see some new digital regulators kind of appear. So a new agency in the mix that will end up working with data privacy and competition agencies around the world.
And I suppose, in-house counsel and in global companies have got to contend with sort of differing regimes as they do, in antitrust and competition law as well.
I think they're at the forefront of contending with the differences between these two areas of law, because if you sat down with privacy counsel and competition counsel, they might tell the business to do something a little bit different when it comes to managing personal data. And so I think that definitely in-house counsel will understand this in deep ways that maybe from the outside we don't.
So you had mentioned sort of coherent digital regulation. Congress has obviously proposed a series of new antitrust legislation. We've talked a little bit about privacy legislation, but new antitrust legislation targeting in many ways these digital platforms. Is there any discussion in those new proposed legislation around privacy as being a concern or a reason to target digital tech firms as opposed to, treating them differently than other players in the marketplace?
Yeah, I think more so than privacy legislation, the competition legislation, the bills that you're talking about in the U.S., which are sort of the several House bills that were introduced in early June that kind of follow on the House Antitrust report. Those are sort of the most vivid example of interactions between these areas of law. And so one of the bills in particular comes to mind, the Access Act, which stands for Augmenting Compatibility and Competition by Enabling Service Switching. Not that you need to know the whole thing, but so this is intended to promote online competition through data portability and data interoperability. And so it imposes portability and interoperability obligations on certain digital platforms that meet specific criteria in the bill and that are designated by the DOJ or the FTC. And it's interesting for this interaction of law because there's accommodation within the bill for data privacy and data security. So before data is ported, there has to be affirmative consent from the individual whose data is being ported. And the recipient of the data has to ensure the reasonable security of that information. So we're seeing sort of digital competition as we sort of seek to revolutionize antitrust law in the US. We're seeing that it has to sort of think about and consider data privacy and how that will be accommodated. The bill is a pretty unusual, sort of an odd duck in an international context because usually data portability is about individual rights. So my ability to move my information, and it's within the ambit of federal data privacy law. The US doesn't have omnibus federal data privacy law, so there's nowhere to put that. So it's appearing in this antitrust-related bill. And it's also not an individual right of portability, as you typically see internationally. It is an obligation on companies to enable portability. So sort of half of what you would typically see in privacy legislation. So it's very unusual, but definitely speaks to this intersection of law.
And can you tell us a little bit about the work that you're doing now and anything forthcoming?
Yes, absolutely. So I'm working on an article about whether data privacy is cognizable as a justification in antitrust law. So that's forthcoming. And then also have the Global Privacy Assembly report, which is extensive and sort of takes you on a round the world tour of everything that's happening in this space. It covers, everything from Colombia to Australia, Europe, and the US, and how agencies are kind of viewing this intersection of law. So that is coming out in about a week.
Okay, listeners, keep an eye out for it.
Certainly a lot happening in this space, and it'll be interesting to see what evolves in academia and in legislation and certainly in practice as well. So Erika, before we let you go, we always ask all of our guests a few questions just so we can get to know you a little bit better. The first is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
This is the question I asked my students in the first day of class. So I can play the drums. I can rock out on the drums if needed. Yes.
If needed.
It's been a little while, but I think it still got it.
That's great. Were you ever part of a band or just learned like were you like percussion band or like you can actually jam on a full on, rock band drum set?
It's a full-on legitimate drum set, although I also had to play timpani when I was in high school. So yeah, I can't say my bands ever went anywhere. The skill set is there. And I guess I'm just thinking of something that you probably wouldn't expect, given that I'm a giant antitrust nerd.
And Erika, I'm sure you do this every day, all day, but advice for young law school students or young lawyers who are looking to do what you do either in academia or, obviously have the trajectory of the career that you've had?
Yeah, so I do see a lot of students. Frequently, I'll see them when they're choosing between two great options. And typically the focus is on what they should do. Should I do this practice area or this practice area? And so my best advice is to think about who you want to do your work with. If you're faced with two great options, then I think that the people that you work with, it typically is an underappreciated aspect of career choices. Certainly, you have to choose a practice area that you like, but beyond that, I've really had a chance to work with a lot of people that I really like. In fact, I got involved in the American Bar Association because of a colleague, Anita Banisevic, who is not only an excellent lawyer, but a wonderful person. So I think if you're going to be up late working hard, as we tend to do in the legal profession, you should try to do that with people that you like.
Amen.
Wonderful. Well, Erika, now we're going to pivot to our last segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So can you pick a number 1 to 25? Erika?
20.
20. Who is someone that you look up to or greatly admire?
So the person who comes to mind first and foremost is one that I bet almost every female attorney on here would answer, which is Ruth Bader Ginsburg. May she rest in peace. We had a great memorial to her in my class this year, and the top student in my contracts class won an RBG dissent pin. So changed the world for the better, and someone who I deeply admire.
And certainly would not be expecting quite the same impact, but what impact do you aspire to have on others?
So I think I aspire to have an impact that is a lasting development of the law. And I know that many of us aspire to that, but I think that it's easy to accept the law as it is. And I think that I'm driven by an intellectual curiosity to try to develop it into something more, something with an inherent logic, something which stands the test of time. And so I think that's really what I'm aiming for in my career and life.
Certainly in the right area of the field and academia to be making that impact. So I'm looking forward to reading more of your papers in the years to come. And Erika, thank you again for joining us on Our Curious Amalgam. And to our listeners, thanks for listening, and we'll catch you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.